The law is for everyone to follow, and no one is exempted from it, not even lawyers. No matter how intelligent they think they are, karma always gets them. Can attorneys get away with anything? Can they sway a ruling in favor of their clients or even themselves? Watch the video to see how these attorneys get owned by cops for breaking the law.
Las Vegas attorney in some trouble for a series of alleged late-night rendezvous with one of her clients.
Hal Uhrig, an area criminal defense attorney from Orlando, made headlines all over the country. Hal Uhrig, who represented George Zimmerman in the Trayvon Martin shooting incident, was arrested on various charges, which included soliciting perjury and tampering with a witness or victim. Marcos Lopez, Osceola County Sheriff, said that Uhrig took on a case involving a man named Krishnath Prasad, who had been charged of raping a 9-year-old girl. Uhrig was accused of holding a meeting with his client, the victim, and her father. Uhrig tried to cut a deal to keep the suspect from going to jail. During their meeting, Uhrig instructed the victim and her father to do 3 things. Firstly, to write a declination, that is a letter to the state attorney saying that the rape never happened.
Basically a letter to the state attorney saying the rape didn't happen.
Secondly, to avoid being served a subpoena so that they didn't have to go to court to testify, and lastly, to lie during their deposition and say that the rape didn't happen. According to Lopez, he wanted to make sure this guy didn't go to trial for rape. He added that Mr. Prasad committed the sexual battery at a time when she was 9 years old, and this is what caused Mr. Uhrig to work a deal out with the victim to try and get Mr. Prasad off on a lesser charge so that sexual assault battery cases will go to trial, and this will be a separate trial against the attorney. Even after being pressured to such an extent, the victim decided to come forward and report the conduct to the state attorney's office in July of 2021. Osceola County started an investigation against Prasad's attorney on the basis of the victim's complaint. The victim's father engaged in a controlled phone call with Uhrig and said that he couldn't talk on the phone about any specifics and wanted to meet in person. According to the officials, the father wore a recording device during his meeting with Uhrig, and during the meeting, the attorney made him turn off his cell phone and told the father to read a script off of his computer screen.
He wore a recording device, the victim's father. During the meeting, the attorney made him turn off his cell phone.
Lopez said that the script was his defense for when he goes to court on the charges. However, fate had other plans for them. Prasad, who was arrested back in 2019, is working his way through the court system. On the other hand, Uhrig is accused of soliciting to commit perjury, which is a 3rd-degree felony, and also for tampering with and harassing a victim, which amounts to a capital life felony. Given Uhrig's 40-year-long career, this might not be the first time he has done something like this. According to Lopez, if you're an attorney, you've been practicing law for a long time, and there's no way you're going to jeopardize your career on something like this, especially at that age. Especially at that age, it's retirement time. So I think this wasn't his first rodeo. Unless someone else comes forward, we won't know that, but that's what I suspect this time. The next attorney in line is Alexis Plunkett. This topsy-turvy case involves a 38-year-old attorney from Las Vegas named Alexis Plunkett, was indicted with 2 counts of conspiracy to unlawfully possess a portable communication device and 12 counts of a portable telecommunication device by a prison. The charges relate to her visit with her 28-year-old client and boyfriend at the time named Andrew Arevalo. This man was shot in the face by a high state correction officer in 2014. He also faced felony and weapon charges and was awaiting trial. His case was represented by Plunkett in his lawsuit against the Nevada Department of Corrections in connection with the shooting, which resulted in another man's death. During her visit, security camera footage shows Plunkett handing over her phone to Arevalo. Now, this is a felony that could land her in jail for a year. However, her case took a complicated turn. Even though the couple started off as boyfriend and girlfriend, they were experiencing rifts in their relationship after her phone was examined by the police. It seems that she is trying to put a hit on Arevalo. Her text messages about her joking about felonies led her to her downfall. Some of the texts read, "I've placed hits in every Nevada prison on Andrew with every homie and lifer I know." She further added, "This pause will never survive in prison now. He's F with the wrong bit. I am not the one. I represent all the sure-knows and he's gonna get it." However, one of the people in the group asked her to delete the message. He said, "Alexis, this isn't funny. I know you are under a tremendous amount of stress, but I'm not interested in joking about felonies. I don't think anyone is either.
She replied, "I am not joking. That's why I said to delete it. He said he was going to have me murdered, so I'll take care of business first."
Plunkett's attorney Adam Solinger said that her messages show that she was under great stress and she was only venting about the bad situation she was in, and that her words shouldn't be taken as a serious threat. Despite all of her 14-count indictment, Plunkett was dismissed by the district judge Michael Villani. However, she was shockingly arrested again for charges of bribing or intimidating a witness, which is a felony. According to her lawyer, her guilty plea comes after reaching an agreement with prosecutors. The agreement is a good resolution for all sides involved. It's the choice that she made that's best for her, and I respect that. Ultimately, it came down to being tired of continued litigation. Fighting a war on two fronts takes a toll on you, and remaining in custody pending your trial and resolution of your other case is really hard to do. She pleaded guilty of possession of a telecommunication device and was ordered to serve 3 years of probation and was later disbarred. In the next case, Christopher Reynolds, a 44-year-old Florida attorney, shocked everyone. He was accused of stealing nearly $800,000 from his clients. He was arrested by the Pinellas County Sheriff's Office for multiple charges, including money laundering and grand theft. He started his private practice in Seminole back in 2015, representing victims of vehicle crashes. He had dealt with at least 16 clients before they had their money stolen by Reynolds. It was back in October that the detectives came to know about the theft when one of Reynolds' clients came forward. The client complained to the authorities that her lawsuit for $100,000 had been settled months earlier. However, Reynolds never notified her about this. The investigators made a shocking discovery. Reynolds had forged his client's signature on the legal documents and collected the money from insurance companies that should have been disturbed to pay medical bills and provide other compensation related to car accidents. This was a similar pattern for most of the clients that had availed his services. Once he had settled his case, he would disappear without a trace, never to be seen again. He would neither pick up the calls or respond to the voicemails, and would cut off all forms of communication he had with the client's eye. In another incident, the lawyer pocketed the woman's $100,000 and continuously lied to her in the communications before it abruptly stopped that he was going to solve this with the insurance company. He also forged the woman's name on settlement documents, and he never paid her medical bills with the settlement money. His highest theft amounted to $148,750 from a client back in 2019. Sheriff Gualtieri claimed that the clients must have had serious injuries for their settlement money to be in 6 figures. Now, what did he do with the money he stole? The answer will shock you. The lawyer had a drug abuse problem. He used a portion of the stolen money to purchase drugs and nearly spent $30,000 on pornography and $424,000 on prostitution. Sheriff Gualtieri later commented, "They're licensed to practice law. They've got the boxes checked. They've got the credentials. They've got the credibility that goes with that, and they're really just a thief who is ripping them off." These are not isolated cases. Many lawyers who are corrupted and have been cheating people for years are roaming free in this world with no one to put a check on them. What do you think of these lawyers? Were they punished approximately? Let us know your thoughts in the comments below. Don't forget to press the bell icon and subscribe to our channel for future updates.
In September 2014, a concerning incident unfolded during a police accountability march in Lynn, Massachusetts, shedding light on officers allegedly breaking the law while being captured on camera. The incident was documented by Ms. Bay, the founder of the Bay State Examiner, an independent media source focused on police interactions and accountability. While attending the march, Ms. Bay noticed an undercover police officer trailing the protest in an unmarked vehicle. Seeking accountability, she approached the officer to request his name and badge number. In a startling turn of events, the officer reportedly hit her with his vehicle.
Howdy. Sorry to bother again. Oh, hey.
Can I have your IDs?
Uh,
You guys are fine, right? Both your IDs. Pardon me? I need both your IDs.
What's lawful reason for the request?
Because you're on private property.
I'm on private property and you get to see my...
In the back lot. You were on private property. You asked to leave. You took your time. I need your IDs. IDs?
can I have yours?
I don't have one on me.
Oh, alright.
Well, go to the chief. We are.
Sure.
That's what we're here for.
Yeah. Can we speak to the chief? This officer has invited us to speak with him.
This incident prompted Ms. Bay to take matters into her own hands. Days later, Miss Bay ventured to the Lynn police station's back lot in pursuit of evidence regarding the vehicle that had allegedly struck her. Her efforts were met with resistance from an unidentified officer who swiftly expelled her from the premises. Undeterred, she entered the police department building to file a formal complaint about the incident and to seek officer identifications. The encounter within the police station would go on to raise a myriad of legal and ethical concerns. The situation escalated when the officers on duty refused to identify themselves and labeled Miss Bay's presence as trespassing on private property. Massachusetts law, however, stipulates that police officers are required to carry identification cards and display them upon a lawful request. This refusal constituted a violation of this legal obligation.
You're welcome
What
to come
sense?
back there and take a look after.
Okay. Oh, after? I'm sorry.
Yeah.
All right.
But we need your IDs now.
I'm not interested in showing that at this
No?
I'm not. Yeah.
All right, so you guys are refusing? All right, then we'll just leave. There you can go. Do we want to check the...
Yeah, I was gonna say, you've invited us to speak with the
Chief's
chief.
a busy guy.
Oh.
You just suggested we talk to the chief.
Well,
Yeah, but I guess apparently he's not...
I'm sorry, what's...
He just told you to do that, right?
No, you told us to talk to the chief.
Yeah, and you came around here and he's not coming down here.
Oh, right.
So maybe you should call him
Call
and
the
make an appointment with him.
Got it.
Okay.
Okay. We can do that.
And
Right.
may I have both of your names and ID
So
cards?
that's
Badge 88. Badge 88.
Badge 88?
Yep.
The officers ordered Miss Bay to vacate the premises, accusing her of creating a disturbance and trespassing. In response, she asserted her right to continue recording for news-gathering purposes. A crucial distinction emerged. While Massachusetts acknowledges the right to record police, this right is not absolute and must adhere to reasonable time, place, and manner restrictions that safeguard officer safety, informants, and victims. The incident also underscored the nuanced relationship between the First Amendment and trespassing laws. While Miss Bay's intent to file a complaint justified her presence to some extent, officers claimed she was trespassing and sought to remove her from the building. Legal precedents highlighted the complexity of these issues, including the right to record police versus the limitations imposed on such activities within police stations.
Not with you. Who do I make a complaint with?
The chief's the best guy.
The chief's the best guy.
Yeah.
Okay.
So make an appointment.
Okay.
What's up with that? What is it that you're looking for?
Well, I found the car that hit me on Friday. I was reporting it earlier. It's out back.
Okay, and what are you doing going in private property videotaping police cars?
What private property?
The property that's parked out back there posted as no trespassing, authorized personnel only.
I didn't see that.
Well, it's posted all over the entrances to that parking lot.
Interesting.
It is interesting, but it is also posted.
Okay.
You're subject to arrest for going back into private property.
Am I being
Videotaping
arrested?
police cars. Huh?
Am I being
I
arrested?
said you are subject to arrest.
Okay.
Despite these legal complexities, officers' conduct raised questions about their intentions and commitment to accountability. Their refusal to take Ms. Bay's claims seriously and their hindrance of her ability to file a complaint cast doubts on their willingness to engage transparently with civilian concerns. The encounter raised concerns about the potential misuse of laws to deter individuals from lodging complaints against law enforcement officers. In the aftermath of the incident, Ms. Bay submitted a Freedom of Information Act request to the Lynn's Record Department.
The officer in charge will be out with you when he gets a second.
Okay.
Talk to you and get your complaint.
Well, somebody does need to tell
Okay.
him that that's what's going
Well,
on.
if he's
because
already done that, then your complaint has been filed and documented.
There's information that he literally doesn't have because I didn't have it until right now. When I went back, I found the car. So I would like to tell him that the car is back there, that it's been repaired, even though they didn't report, I guess. Well, you know what? Actually, I'm filming this for news gathering purposes at this point.
Yet her efforts were met with resistance, and it remains uncertain whether the department ever responded to her request. Her documentation of the event and her subsequent efforts to highlight the challenges faced by citizens seeking accountability and transparency within law enforcement agencies. Now let's move on to the next investigation. In a noteworthy incident that unfolded on June 5, 2015, the spotlight fell on Michael Hoffman, a private investigator and an advocate for the First Amendment. The scenario took place in Jacksonville, Florida, as Hoffman engaged in conducting surveillance as part of a case. His objective was to track down an individual's movements and actions across multiple locations. However, the situation took an unexpected turn when the person under surveillance alleged that Hoffman was stalking her.
Investigator, I'm short.
Can I ask why you pulled me over, sir?
I pulled you over because the young ladies came over there and said you've been following her since she left the airport yesterday. So I want to know who you are.
Have I committed a crime?
No, but I'm conducting an investigation. Have you been following that young lady? I mean, if you're an investigator, investigate away. But if you're somebody harassing her or stalking her, that's against the law. Me pulling you over to find out who you are is me doing my job.
Am I free to go?
No, you are not. Not until I find out who you are. I'm conducting an investigation. Do you have your driver's license, registration, proof of insurance on you?
Have you pulled me for a traffic violation, sir?
No, sir. I've already explained that to you. Now you can play the back and forth rigmarole.
This accusation prompted a response from law enforcement, specifically an officer from the Jacksonville Sheriff's Office. The encounter between Hoffman and the officer was marked by a clash of rights and principles. As the officer initiated a traffic stop, the interaction was captured on camera and later disseminated on the Awakening the Masses YouTube channel. The video depicted the exchange as the officer sought to ascertain the veracity of the stalking claim. He engaged Hoffman in conversation, asking about his identity, purpose, and whether he was an investigator. Hoffman's response was calculated and assertive. He began by asking the officer the reason for pulling him over, which initiated a dialogue regarding the stalking allegation. The officer cited the complainant's assertion that Hoffman had been tailing her since previous day. Despite Hoffman's protestations, the officer deemed it necessary to investigate the matter. He explained that his actions were guided by the need to ascertain whether Hoffman was involved in harassing or stalking behavior, which is legally prohibited.
Oh, tell him to come up here. We're at the 8100 block of Arlington Express.
I don't answer questions, Deputy.
You don't answer questions. You just stalk young ladies. Just stand by this. Stand by.
Your name and badge number, Deputy? Your name and badge number, Deputy?
Hey, buddy, what's going on here?
Name and badge number, sir?
Simpson 66190.
Masinsin, M-A-S-I-N-S-I-N. Sir, I'd like to know why I'm being detained.
No, someone's saying that you're claiming your stock, and are you an investigator or anything?
Okay, let me make this clear, sir. I would like for you to articulate what crime you...
The crux of the disagreement hinged on the rights invoked by Hoffman. When the officer requested identification, Hoffman invoked his Fifth Amendment rights, a constitutional privilege against self-incrimination. This assertion caused a pivotal shift in the interaction, as Hoffman insisted he would only speak in the presence of legal counsel. The officer, seemingly perplexed by this response, requested that Hoffman bring his attorney to the scene for further questioning. Hoffman's stance was rooted in legal principles. He argued that during a Terry stop, law enforcement could pose a limited number of questions to establish identity and to determine if any suspicions were valid. However, Hoffman remained steadfast in asserting that he was under no obligation to answer questions without the presence of legal representation, especially considering the potential implications of his responses. The officer's actions were grounded in the assumption that a stalking accusation, combined with a corroborated vehicle description, constituted reasonable suspicion for a stop and investigation. This view aligned with legal precedent, exemplified by the 2002 case of United States v. Sokolow, which allows law enforcement to act on a tip if it bears indicia of reliability. The Supreme Court has ruled that reasonable suspicion necessitates a particularized and objective basis for suspecting wrongdoing. Despite the differing interpretations, the encounter eventually concluded with the officer permitting Hoffman to leave. The tension between rights and responsibilities underscored the complexity of police-citizen interactions.
Some professional courtesy and treat me with the respect I deserve. What is your name and badge number?
Well, here's sir. I gave you mine. 0051.
Thank you. I appreciate that, Deputy. Was that so hard?
No.
The law states I don't have to give my name and information unless you suspect me of committing a crime.
You don't.
Then am I free to go? Because this is an illegal detainment.
At this time.
This is an illegal detainment.
But like I said, your criminal matches the description we were given.
I respect
Doesn't
that.
mean
I respect
you're guilty.
That. I respect that. You're talking to an ex-law enforcement officer, buddy. Now, I understand you're doing no fault with that. You are doing your job.
Okay.
And the mere fact that I'm exercising my legal rights does not make...
Shedding light on the importance of understanding legal rights during such encounters. Hoffman's case emphasized that individuals have the right to remain silent and request legal counsel during a Terry stop, while officers must balance their duty to investigate with the requirement to respect constitutional rights. The incident became a case study in navigating the delicate balance between law enforcement's duty to investigate and an individual's rights to privacy and legal protection. As the video disseminated, it sparked discussions about the scope of police authority during stops, the validity of accusations, and the intricacies of the Fifth Amendment privilege against self-incrimination. Michael Hoffman's assertiveness in upholding his rights and the officer's attempts to fulfill his duty encapsulated a pivotal moment in the ongoing dialogue about law enforcement practices and individual freedoms. Now let's take a look at the next investigation. In April 2020, a situation involving Lynn Hill and Denver police officers unfolded after a minor traffic incident on Interstate 25 in Colorado. The incident escalated into legal disputes, allegations of rights violations, and concerns over police conduct. The episode began when Lynn Hill, age 25, called 911 after a minor collision with two other drivers. Officer Thomas Ludwig of the Denver Police Department arrived at the scene and initiated discussions with the other individuals involved while Hill was being evaluated by paramedics inside an ambulance. The situation took a turn when Hill exited the ambulance and noticed Officer Ludwig searching his vehicle without consent.
What are you doing? Stepping to me, huh? What the f*** is in my face? What do you think so, dude? What is this? Oh, what am I? What the f***?
What are you stopping the cops for, man?
I did not ask you to get out of my car.
No, I watched you. I got you on my video camera.
I asked you to get out of my car. That's it.
You're being an asshole to everybody.
I'm not.
Yes, you are.
Oh. That's it, right to work, brother. Ow. You can't get it up. Money. What did happen? You got a ankle monitor too, huh? Wow.
On probation, I'm sure.
I'm not on
The
probation.
probation officer's gonna love that.
I'm not on probation at all.
The officer claimed he detected the odor of marijuana, implying that this gave him the authority to conduct the search. The legality of such searches based on marijuana odor varies across states, and in Colorado, where recreational marijuana is legal, the odor can contribute to probable cause for a search. However, legal nuances exist. Hill confronted Officer Ludwig about the search, leading to a heated argument. The officer's aggressive response escalated the tension instead of employing de-escalation techniques. While Hill's behavior might have prompted concern, it's questionable whether it warranted the officer's level of aggression. Hill was arrested and charged with interference with police activity. These charges were later dropped, but the incident spurred Hill to file a lawsuit against the city of Denver and the involved officers.
I'm not intoxicated at all.
Go ahead and have a seat in there.
Go for it. Please go for it.
Okay, have a seat.
Y'all are illegally searching my car.
Have a seat. Have a seat. Put your feet up.
Bro.
Push yourself all the way back.
He alleged violations of his First and Fourth Amendment rights and claimed damages, including missing a master's degree final exam due to his incarceration. Critiques of the officer's conduct centered on several points. Firstly, despite the possible legality of the initial search, the decision to arrest Hill was deemed unnecessary and potentially unconstitutional. Officer Ludwig's unprofessional behavior, particularly his failure to de-escalate the situation, garnered criticism. His confrontational approach escalated the disagreement rather than diffusing it, highlighting the significance of emotional awareness in police interactions. Moreover, the officers faced criticism for their response to Hill's request for medical assistance. According to the Denver Police Department's Operation Manual, officers are required to provide medical attention to individuals in custody. Hill's expression of uncertainty about his injury should have prompted a more compassionate response from the officers, as opposed to the callous indifference displayed. This incident underscores the complexities of police interactions and the importance of effective de-escalation techniques. While the legality of certain actions can be ambiguous, officers should prioritize public safety and citizens' rights. Emotions and situational awareness play crucial roles in determining the outcome of such encounters.